Hello, my name is Thorne Barasa, the president of the ICJ in Gluns, and this shall be our class on the sources of law in the ICJ. So we've looked into what the court is, we've looked at jurisdiction and its power to listen to issues. But, where exactly does the law come from? And the sources of law in this case refer to the materials or the documents or the authorities that the court can use to determine what the law is. So the question we ask ourselves is, where does the ICJ find the rules it applies? Sources of law can be many things. For example, in our Kenyan context, we have the Constitution, and any state has its Constitution as its primary source of law. We have statutes. Statutes are the acts of parliament. You have customs. You have principles of law. You have international law. But for the ICJ, what does the court use to determine what the law is? And that is where the Statute of the International Court of Justice, or as we agreed we'll be calling it going forward, the ICJ Statute, speaks on this matter. And Article 38 of the ICJ Statute states that, or rather, the primary authority governing the sources of law in the ICJ is Article 38 of the statute, and it is the most authoritative statement of the sources of international law considered by many courts. So, Article 38 directs the court to apply specific categories of law when deciding cases, and they are treated as the foundation of international legal reasoning and are very important for both real-world litigation and MUN. So, what are the primary sources of law? 1. Treaties. Treaties are also called international conventions, and these are written agreements between states establishing legal obligations. And the importance of treaties is because, 1, parties not only ratify but sign to be part of the treaties, and secondly, they have obligations that ought to be followed by all states from the principle of good faith. Now, a good example is the UN Charter, which creates obligations that states might follow. And when disputes arise on the application or the following of obligations of a treaty, the ICJ can listen to that matter. So think of treaties as contracts of international law, and they're the most direct expression of state obligations and state consent. Second thing is something called international custom and customary international law. And so customary international law arises from the general and consistent practice of states, followed from a sense of obligation. So for customary international law, there is 1, general application. It's not something done by one state, it's something done by more than one state. It has to be consistent. There isn't a time limit as to how consistent something is. However, there shouldn't be breaks between which a certain custom has been followed. For example, when important people show up, when world leaders show up, you have a red carpet rolled out for them, right? So when, say, I become a world leader, this is the part where you say amen. When I become a world leader and I show up to this country and they don't roll out a red carpet for me, I will ask, okay, why didn't I have the red carpet rolled out for me, right? So that's the example for how customary international law works. It has to be consistent, it has to be general, and it is followed out of a sense of obligation. For example, 3 states decide that they shall reduce their tariffs by 10%. And we have no obligation to follow that, but we feel like by doing this, it will help us in a certain way. So for customary international law, it has to be general, consistent, and it is followed out of a sense of obligation. This means that customary international law is not written down, but it is a rule that will still be legally binding amongst states where they have consistently done that and they are then required to do so legally. And it is basically unwritten law that develops over time as how the states behave. Now, third, we have the general principles of law. And these are fundamental legal concepts that are common across all domestic systems. And the general principles of law include fairness, good faith, and the idea that all agreements must be kept, which is called pacta sunt servanda. These principles are used by the courts to fill gaps where there are no treaties or customary international law applying. So where there is no agreement, there is no behavior that has been practiced consistently, we will come to the principles of law. We have fairness, duty to uphold justice, and that's what the court is there for. So you don't need to have a treaty, you don't need to have a practice, but the general principles of law can still apply. So these are like the basic logic of law, and it exists across different legal systems. But in addition to the primary means, there are also subsidiary means, or like secondary means, for determining law. Now, these have also been specified under Article 38, and they do not create law, and they need it to be very clear. The primary sources create law. The secondary sources do not create law, but they assist the court in interpreting and applying it. Why is this important? You can't come and quote this as a source of law that creates law, but it's a source of law that helps to interpret it. For example, one of the secondary sources is judicial decisions. So the court can refer to its previous judgments as persuasive authority. What does that mean? When the court has passed a judgment between State A and State B, the judgment is only binding to State A and State B. When State C wrongs State D, the court can use the judgment it passed when they were handling the issue for State A and State B and say, this is how we ruled here. We are more inclined to rule this way in this case. It does not mean that that is law. It means the court said that when we were faced with this issue, this is how we handled it. We are faced with this issue again, and borrowing from what we did in that other case, we shall apply this here as well. That is what it means. It is not binding, it is persuasive. Because the ICJ is not strictly bound by precedent. That's the doctrine of precedent. The doctrine of precedent in Latin is called stare decisis, which means let the decision stay. Meaning that when the court has handled a matter in a certain way, there is no other way the court will think of handling that matter. For instance, if the school says if you steal a pencil, you will buy 5 more. If someone else steals a pencil, the school will say, okay, as we decided before, you will buy 5 more pencils. But the ICJ does not work like that. The ICJ will say, last time we look into the fact that you stole a pencil and you're buying 5 more. And this time, since we have the similar issue, we will look into 1, why did you also steal this pencil? And 2, the fact that you can buy more than 5 pencils. And so we will ask you to buy 10. That is exactly what that means. Therefore, the ICJ will not rely on cases as precedent or the principle of stare decisis, but it will rely on the cases for guidance and to ensure consistency. So that, as I've said, issues that have been handled the same way are consistently handled that way. We don't have one state saying, when it was my case, this is what happened, and another state saying, it was my case, this is what happened. Then, secondly, we have scholarly writings. Scholarly writings are the works of highly publicized, or rather highly qualified publicists, authors of international law who are respectable. Their books, their papers can also be used to guide the court on how to interpret matters. And it helps especially where the law is unclear or the law is evolving, and so they write on these matters, and the court can use these works to interpret the law. And there is also the principle of equity and fairness under Article 38 of the ICJ Statute, which in certain instances, the court can be determined, or rather the case can be determined according to what is just and what is fair, and not just following the legal rules. And that is why we have equity. The law of equity came in to remedy the harshness of common law, because, well, common law or laid down law was deemed very harsh, and especially in certain instances where you've said, if you have stolen one pencil, you buy 10 more, but you find someone who really needed that pencil to do an exam and they stole one and they could not afford any pencil. So do you still ask them to pay 10? And that is also where the court allows that where the legal issues or where the legal rules are very harsh, it can be decided according to what is just and what is fair. And in Latin, you will learn a lot of Latin in this. In Latin, it is called, the court can decide a case ex aequo et bono, meaning according to what is fair and what is just. However, equity and fairness can only apply where both parties agree. So it doesn't just come to be that I feel like, wow, this is too harsh, you can't ask me to do this. The other party might come and say, no, this is exactly what I need, there is no other resolution I'm going to accept. So where both parties have come and agreed, and I come and ask the other party that, hey, I understand I have done something wrong, however, instead of doing this, can I do this instead? And the other party agrees, then this principle can apply. So how do all this apply in the context of MUN? Understanding the sources of law is very important, especially in constructing legal arguments or in drafting legal policies. And the delegates must base their submissions on recognized legal authorities rather than general statements or political claims. So I don't expect you pick a random blog on the internet and come to it before the court. I don't expect that you come to court and you say, Your Honor, I'm the one saying, you're not a legal authority. There have been authorities laid out for you to be able to do that, and you ought to base your legal arguments as a delegate on these authorities. And so a well-prepared delegate will do the following. They will cite relevant treaties and explain their application. It's not just enough to bombard us with the law. You need to explain why this treaty applies, to identify customary rules and support them with examples, especially where you've said they're general and consistent and there's legal obligation to follow them, to use general principles to strengthen arguments, and to refer to past ICJ cases for persuasive authority. When you come to court, it is easier to tell the court to rule in a certain way when you show them that they already have in a previous case, because courts interpret the law and now they decide how issues should be interpreted. And so before a case, it's easier for you to use ICJ cases. And it transforms argument from opinions to legal reasoning. And that is all the time we had for sources of law. Thank you very much, and I will see you in the next one.